Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, Harvey Weinstein is back in the news again, and we'll talk a little bit about some of the appeal allegations he's made in just a second. So the whole Me Too movement got started, I think, with Harvey Weinstein. Weinstein was a producer and director of films in Hollywood, and apparently the rules that govern the rest of us throughout the United States just don't seem to apply in Hollywood. It's sad, but it's also true. And so Weinstein elevated the role of the casting couch to basically, if you want to have a part in my movie, you're going to have to engage in with me, and that is indeed a loathsome behavior. And he has also been convicted of out in California, so maybe the law does reach out there, but it took a really long time to bring those charges. And so as a result of that, the Weinstein case got a lot of publicity. And of course, the first trial, which occurred in New York, also resulted in a conviction. Well, although convicted in the California court, he is appealing the conviction in New York. I'm sure he'll appeal the conviction in California too. Most of these people who have the money to do so, do so. So he's going to appeal in New York for a number of reasons. And some of those reasons are actually pretty interesting. And he might have an opportunity, he might have a shot at getting his conviction overturned. Let's look at some of those reasons. One of his first allegations is that the judge succumbed to pressure. In other words, the judge did not want to be criticized for ruling favorably to Harvey Weinstein, so he ruled favorably to the prosecutors. I can pretty much assure you that every criminal who has ever been convicted has told their lawyer something to this effect. The bottom line is that the prosecutor does seem to get a little bit of favorable treatment from most judges. In the one criminal case that I was involved in, where I represented somebody who was engaged in similarly loathsome behavior, the bottom line was the judge definitely ruled in favor of the prosecutors on close calls. But stripped of the facts of each of these individual rulings, because the brief has not been released to the public yet, the New York Court of Appeals, which is the Supreme Court of New York, and the trial court in New York is called the Supreme Court of New York. Go figure that out. New York has to be different than everybody else. But in any rate, the Supreme Court, or the Court of Appeals, has not released the brief yet. It hasn't been filed by the clerk's office, apparently. But in that brief, many of copies of which were released to the media, of course, there are a number of allegations about inappropriate evidentiary rulings. And some of those rulings could indeed come back to bite the prosecutors. But not all of them, and not necessarily the ones that are complained about in the brief. So part of the allegations against this trial judge are that he swayed the outcome because the jury could see that he was very favorable toward the prosecutors, and thus he must believe that Weinstein was guilty, and that somehow swayed the jury. I don't know how you would ever prove that. The best way to actually make that allegation is through what we call cumulative error. In other words, even if one or two of these errors are not eligible for reversal on their own, the fact that there were so many contributed to an unfair trial. That is sort of the argument I think they are making here, but I'll have to wait and see the brief before I go there. One of the things that the judge did was he allowed testimony of witnesses who claimed that they were attacked and they were sort of forced into inconvenient circumstances by Weinstein. It is permissible to have uncharged other acts of criminal conduct only in certain conditions. If you are trying someone for assault, as an example, testimony by other witnesses who were present at the time and who the person charged with assault also threatened and tried to fight would be most likely admissible because it shows a pattern. And in some instances, a prosecutor can get evidence of other uncharged acts of criminal conduct before a jury if he does it the right way. Now, this is Rule 404 of the Federal Rules of Evidence, and this is what it says about the issue of uncharged acts in a criminal case. This evidence may be admissible for other purposes such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Absence of mistake. You know, I believe that in many cases where you have a situation like this, somebody says, hey, look, I thought she was a willing participant. Lack of accident, right? And also absence of mistake. Hey, you know, we were amorous. We got, you know, we were having fun, and then it got a little bit out of hand, and it was a mistake. It wasn't intentional. Well, absence of mistake, and then also plan. You know, in each of these cases, the suggestion was that Weinstein had these people up to his apartment or his house or his trailer at the studio, and then when they showed up, he was in his bathrobe and naked underneath, things like that. That shows plan. And if that plan was similar in each of these cases, again, that goes to the evidentiary value of those things. So I'm not really certain that Weinstein will be successful in this evidence of other uncharged criminal acts appeal. I think that point in appeal should probably be at the end of the brief, not at the beginning of it, because I don't think it has much of an opportunity to succeed given what has been reported in the media. Now, I'm not his lawyer, and his lawyer will certainly make a decision based on what he knows, and I'm sure he'll make the right one. Another issue has to do with juror bias. Now, juror bias is an important fact, and if you have a juror who is obviously biased and there is evidence of that bias, then it is important to err on the side of caution in that situation if you are a judge, because an appeals court might very well look at it as a huge mistake and something that is going to cause this trial to be retried. In this particular case, one of Weinstein's jurors had written a book about a predatory older man, a sexually predatory older man. And there were enough similarities between Weinstein and the characters in that book that certainly made it appear that she had a little bit of bias in that regard. Now, traditionally, what lawyers do is after exposing that bias, the other side will come back and say, now, Mrs. Smith, can you be fair? I mean, can you put aside everything you wrote in that book? And because, I mean, that you wrote a novel, it was just a made-up story. Can you put all of that aside and be fair? And, of course, people usually say, yes, I can. If you ask someone if they can be fair, everybody says, yeah, I can be fair. There are a few people who say, no, I just don't think I'm the right juror for this. But most people believe that they can be fair even if they can't be. Again, in a situation like this, it is far better to err on the side of caution and boot that juror and bring in somebody else than to let them have an opportunity to be involved in the case and perhaps taint it. Now, another issue that they have raised in their brief is the fact that the prosecutors brought in expert witnesses on victim behavior, and they were allowed to do so. The defense asked to bring in opposing experts, and they were not allowed to do so. Now let me illustrate that a little bit too. Most states now have adopted this Daubert rule, and they make the judge the gatekeeper of scientific evidence. Well, social science tends to be less of a hard science than does biology, chemistry, any of that kind of thing. Hard sciences are fairly easy to distinguish. People write peer-reviewed papers and get them published. It's fairly easy to establish somebody is an expert in a particular field. But in social science, particularly things like victim behavior and the testimony of eyewitnesses, a lot of the data and a lot of the research is gained through social science research, which is always subject to attack and may be subject to exclusion on other grounds. So, since we don't know exactly who the witnesses were and why they were excluded, they may very well have been excluded because they were not fit, they were found to be someone that would not help the jury, then that was perfectly appropriate, and that also will probably have no opportunity of going forward. Finally, one of the things that the Weinstein attorneys raise is this issue of the judge creating a carnival atmosphere, of him succumbing to all of this publicity and public pressure and just letting the prosecutors have a field day. Okay, I get that. I would assume that if I was in this situation, I would probably make a similar argument. I would probably not say carnival atmosphere. But that's the choice of the word for, and maybe that works in New York. I don't know. I can tell you in Missouri it would anger the Court of Appeals to see that kind of language in an appellate brief. All of this gets down to whether or not that conviction can ultimately be reversed. I have no opinion on that. It could very well be, it may not be. But I have to say that the first appeal that he made in the state of New York was rejected. The New York Court of Appeals, the intermediate appellate court, rejected that argument. And then he was granted leave to appeal to the full Court of Appeals, what sits as the Supreme Court in any other state, the New York Court of Appeals, on all of these issues. And we'll just have to see how that court resolves these issues. Thank you very much for watching. If you have any questions, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel. Click on the notification bell so you can be notified anytime we release a video on the channel. Thank you for watching and have a marvelous day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.